to 11 and I'm Sneha Shrestha. We're presenting on the topic Fraport AG Frankfurt Airport Service Worldwide versus Philippine government, and our group members are
I'm Manu Shrestha.
I'm Sajna Rana. I'm Tahmina Akhtar.
I'm Soyang Zhao.
In this case, Fraport company is the claimant and Philippines government is the respondent. A claimant is someone making a claim and a respondent is a person in the position of a party defending a petition. In 1997, Pietco, a Philippine-based firm, came into concession treaty to develop and operate a public international passage terminal 3 based at Ninjoy Aquino Airport in Manila. The primary dispute concerned the application by Fraport of an ICSID award annuitment which was issued in 2007. Although the Philippines government claimed that the arbitration tribunal was claimed that not evenly represented and that it lacked the requirement jurisdiction as the claimant model of investment was made by a violation of local legislation. Hence, it was entirely in breach of the bid Article 1 section as per Antonietti 2014. Fraport filed yet another lawsuit about the annuitment of the construction and with regard to Article 52 Section 1 of the ICSID jury, where he stated that the respondent and the tribunal have unfairly exceeded the powers in giving the determination, but the procedures used in the award was not well reasoned. Thank you.
I'm Sajna, so I'm going to continue the initiation of disputes. Philippines government declared that the treaty between Fraport and Pietco as void since it's the violation of local legislation and breach of bilateral investment treaty. On December 6th of 2007, Fraport filed application of ICSID requesting annulment of award and claimed for arbitration request through bilateral treaty between Philippines Republic and German Republic. Philippines government respondent claimed that investment made by Fraport was against the investment law and the issues were admissible as there is violation of standard BIT. Hence, the decisions were given in favor of the respondent. So further action of Fraport were unfairly exceeded the power in giving their determination and the award were not reasonably responded and was not able to analyze the entire investment by the firm. These were the further lawsuits regard to the section 52(1) of ACSID.
So I am Tahmina. I am just doing the legal issue presented. The case of the Fraport based the Philippines was all through legal. Legal means which is legal by law. It requires a court decision. Generally, the legal issue involves a conflict that was created by the respondent when it is refuted almost complete construction of Terminal 3 of the airport by President Gloria Macapagal-Arroyo. The government claimed that the construction agreement was illegal as per the national policies and that firm had acquired the concession. The Fraport, which was under the Pietco from the following to achieve the financial aspect of the concession during the period application process. Many of the cases under the attribution tribunal failed to bring forth any positive result and claim starting in 2001 and it was until 2010. The case was later structured starting from the year of 2011 when a well-composed attribution committee was finished. Then, led by the Professor Prior from Italy, the respondent was represented. And in the year of 2000, Pietco had gotten a proper and valid award of the Terminal 3 concession. Also a legal issue, field by the Pitaco invested, which was $420 million back 2003.
I'm going to tell you about the individual parties' argument. First of all, Fraport had many arguments in favor of its concession agreement with the government. There are 10 responses to the issue we declared, but today I'm going to tell you a few of them. For example, Fraport wanted the Philippine government to pay it the full amount of the damages the substantial experience as a result of the breach of the agreement through the amount that would be agreed upon. They also the Philippines to be the order to reimburse it for the entire cost that would cover for the abbreviation process, including the expenses and legal fees and all the fees that the center would require. On the other side, Philippines had several arguments and requests to the arbitration committee. They argued that the tribunal should take the initiative and dismiss any claims made by the claimant entirely, as the issues presented lack of the correct jurisdiction and that they are inadmissible. Also, the Philippine government wanted the tribunal to make decision about the case in their favor with regard to all the counterclaims presented, and the claimant bear all the costs incurred during the arbitration process. Thank you.
Regarding this case, I'm gonna talk something about the individual argument made by Fraport and the decision of the case and the relevance of this case regarding the trade environment. In the individual argument made by Fraport, discrete investment was the major issue, where the Fraport is stating that the equity investment was not made at one time. It had been gradually made in certain years, where the initial investments were as in the form of loans and guarantees in 2000 and 2001 to the shareholding in Piatcos and Cascadet companies. Fraport submits the award, shows on its face, and the tribunal did not approach the evidence as Fraport breach of Section 2A of the ADL, applying such a presumption. And the right to be heard was another argument placed forward by Fraport, where Fraport alleged that there had been a failure to observe a fundamental rules of proceedings in that tribunal failed to hear it by the way of rebuttal on the significance of new evidence admitted after the closure of the proceedings, breach of the right to be heard. And further, Fraport argued that the tribunal breached the principle in admitting the evidence and substantively relying upon it after the close of the proceedings without giving Fraport an opportunity to address the new materials. And with the arguments placed by both Fraport and the Republic of Philippines, the following decisions were made on this case. Like, the community unanimously decided to annul the award of 16 August 2007 in the Fraport AG Frankfurt Airport service worldwide. Each party shall bear one half of the cost incurred in connection with the annulment proceedings. Each party shall bear their own partly costs and expenses incurred with respect to the annulment proceeding, and Philippines has been awarded 5 million in arbitration against the German firm Fraport AG. And the significance of this case are this case helps in development of the international law, in that it enables the firms and countries to set essential precedents and notes that would be applicable in case of similar situation, which helps in reduce the corrupt deals between nations and the firm at the expense of the government. The fact is also essential as it enables the domestic firms which have little resource to be protected by both international and domestic laws, against the operation by vast and reputable firms like the German Fraport. Further, this case was essential and makes the firm to engage only in just and honest deal to avoid incurring losses when the contracts are refuted. Thank you.